New law says the new tenants, when they move in, there should be a oven range or whatever and a refrigerator. Is that for new tenants or existing tenants also?
It's for new tenants and for existing tenants anytime a lease is extended or continued. So if you have a pre-existing tenant that moved in, let's say 10 years ago, and tomorrow you're going to serve them with a notice of rent increase, that will trigger that law, because by serving that notice of rent increase on a month-to-month tenant, you continued and extended their tenancy. And that will require you to make sure that there's a landlord-owned refrigerator and a landlord-owned stove in the unit, unless they want to use their own, and you can make a proper arrangement with that by way of entering into a written agreement with them on that.
So if I'm doing a rent increase, I have to give them the option if they want
Yes.
to. Okay.
It's not about telling them or not telling them. If they don't have a landlord-owned refrigerator and stove, then the unit is inhabitable. Whether you told them or not, it doesn't matter. The unit is not habitable. They can find one of the extortionist law firms to sue you for habitability or lack of habitability per statute. It comes with mandatory attorney's fees, and it can spiral out of control for no reason. It doesn't say specifically that you must inform them. It says specifically that you must provide it. If you don't bring it up, the unit is not habitable. And if the unit is not habitable, you don't have the right to demand, collect, retain rent, and you expose yourself to a habitability lawsuit, which we see is on the rise in California. I recommend actively communicating to them their right under the law to have a landlord-owned stove and refrigerator, to offer to provide it. And if they want to use what they currently have them sign a certain agreement that needs to have specific language in it to effectuate and facilitate their need.
Like if every tenant form like a choice, then choose if they want to.
It's you can phrase it as a choice, so long as they end up signing an agreement with the sufficient language that they are using their own, then you're good. But if they don't sign it, you need to pursue installation of a refrigerator and stove that is owned by the landlord.
And is there any requirement how big the fridge is? It doesn't.
Yeah, that's a good question, and that's a question that I've been receiving from many clients since the enactment of this law. Unfortunately, the law doesn't specify the size, or it doesn't give a minimum standard for either the stove or the refrigerator. I think that you need to just use common sense. If there's a family or one bedroom, don't give them a mini bar that you find in a hotel room, right? But at the same time, you don't need to go and buy the most expensive refrigerator on the market.
Just to chime in, I have had clients that went and, or that have larger portfolios that were buying used refrigerators, and he would take out to the tenants and say, "I don't want this." He's paying like $400 for a fridge. He said, "I don't want this refrigerator. That this checks the boxes for you to have a refrigerator." And then say, "No, you know what? We'll go get our."
So we'll keep the one that we have.
So long as they sign an agreement that they're keeping the one that they have, you're good to go.
Have a 7 unit in Covina. Two of the tenants got into an altercation, and one causing the other person scratches and physical injuries. And the aggressor was arrested. And now the other tenant was injured, asking me to help them serve the court notices plus a restraining order. So I myself feel like I shouldn't get into their personal behaviors. I don't want to get in between of those. I like to know that the landlord has the duties to help tenants serving a restraining order.
Thank you. That's a good question. No, you do not have a duty to, you're not a process server. There's the sheriffs that provide these types of services. but you may want to take steps to evict, right, the tenant that's at fault. Maybe both of them are at fault and both of them need to be evicted.
Yes, and I have go by the police report and I ask the aggressor to vacate.
Yeah. So usually you don't want to keep a violent tenant at the premises, because if this happens again, you as the landlord are a little bit more culpable. So if you have sufficient facts to assign blame on him or on them, I would recommend serving a notice to quit for assault and battery, which is illegal activities, and filing an eviction.
I've heard about the old court case of Schmidt v. Felix, and that some people understand it to mean that one of two adult occupants can be released from obligations or under a month-to-month lease with 30 days' notice without the other vacating. What is your understanding of its relevance in connection with modern leases that include joint and several liability? How can landlords best protect themselves from having a higher income roommate vacate and then being stuck with a lower income roommate who can't really afford the place on their own?
If they can't afford the place on their own and they don't pay rent, you evict them. You're not going to be stuck with them. You're just going to need to spend money to evict them.
So that there's not having something like having roommate A.
Let me respond, because I know that case, and that's also an issue that we get calls about a lot. So there's a misconception that if two tenants, just for an example, two tenants sign a lease, 12-month lease. The lease is over, they're now month to month. The misconception is that if tenant B wants to move out, a lot of landlords, not small landlords, big companies, sophisticated landlords, they will require both tenants to vacate, or at the very minimum, for tenant A to release tenant B from the contract or from the tenancy. And that is not the law. A month-to-month tenant can give 30-day notice to the landlord and vacate the premises without the co-tenant releasing them and without remaining responsible for the tenancy. Unfortunately, that's just what it is. I don't think that there's any way to circumvent that.
Thank you.
We were thinking about giving the tenants a notice, but what I wanted to know, the appliances that they have, are they to be, when we replace them, are they to be broke? No, they're not usable and they need new appliances. Exactly, how does that work if they have their appliances now?
So I'll give you an extreme example. I'm your tenant and I'm on a month to month, right? I go to Best Buy and I buy the best refrigerator, $10,000 refrigerator. I install it. Then this law comes into effect. If I want you to install a new refrigerator, even though my refrigerator is perfectly fine, I have the right to ask for that, and you have the duty to either install it regardless of me asking, or having me sign a certain release that I'm using my own refrigerator. Okay? So that's what it is. It doesn't matter if my refrigerator works or not. What matters is that I own it. And if I want you to install yours as the landlord, you need to do that.
So it's okay to give notice to all of the tenants.
Yeah, I don't know what the notice is going to say, but at the end of the day, you need to have every unit that you own needs to have your refrigerator and oven, or a document that the tenants signed that they're using their own.
Oh, right.
There shouldn't be any unit in your portfolio that the tenants own the refrigerator and oven and you don't have that document signed.
Right. Yeah, I'll call.
And then you can just pass the mic.
Okay, when you're talking about the refrigerator and the stove things, does that apply to the existing tenant, or does it apply to the new tenant?
Yes, and that's a question that was asked. It applies to all tenants. All
Even
new
though the
tenants, existing tenants, when you extend or continue their tenancy. So if you have an existing tenant that predates this law and you serve them a notice of rent increase, that triggers that law. It's kind of a gray area. There's no law that says what triggers extending or continuing. Let me give you an example. If I'm your tenant and I'm now on a month to month, and then you offer me a 1-year lease, you just extended my tenancy without serving me necessarily a rent increase notice, right? Or what if I'm your tenant and I'm on a month to month, and then you offered me to sign a month to month tenancy agreement? That also extended it, right? Or what if I'm your tenant on a month to month, and let's say it's a jurisdiction that you're allowed to give a 60-day notice to terminate the tenancy. So you basically extended my tenancy for 60 days. That will trigger the law. In my opinion, we shouldn't try to look for what triggers it and what not. In my opinion, you should just assume that everyone needs to have a refrigerator and oven. That's, in my opinion, the best practice.
Hey there. A few months ago, as a result of a lawsuit, HUD dropped their guidance on basically insisting that landlords accommodate emotional support animals and waive any fees. What is currently your recommendations for best practices regarding collecting pet rent or deposits as long as they don't exceed 1 month's rent total for emotional support animals, either in units that allow pets or in units that do not currently allow pets?
You cannot accept or demand security deposit or pet rent for emotional support animals. It's a big no-no.